Rauranga tira mā tēnā koutou, ara tēnā rā tātou katoa. Ms Anderson, before we begin, I'm conscious that we have a new grouping of people in our public hearing and no doubt watching online who have not had the introduction of the commissioners. So I'm going to take this opportunity briefly again to describe ourselves and introduce ourselves for those who don't know who we are. So, good morning, everybody who are present today and watching on the live stream. For your information, my name is Coral Shaw. I am the Chair of the Royal Commission. I describe myself, for those who cannot see, as being an elderly Pākehā woman. I have short white hair. Today I'm wearing a navy jacket and a grey top. And apart from wearing glasses, I don't have a disability. I'll now introduce my fellow commissioners, Dr. Edward T. Sartwa. Thank you.
Tēnā koe, Chair. Tēnā koutou katoa, mā hara mai koutou ko Anaru Eruiti toku ingoa no Taranaki, ko Taranaki te maunga, ko Ngāru e Hinirangi te iwi. I'm Anaru Eruiti, and I'm middle-aged Māori male with a polka dot tie and a blue suit and white shirt.
Kia ora. Paul?
Kia ora, Paul Gibson. I'm a middle-aged Pākehā male with greying hair. I'm wearing a dark suit, white shirt, punamu, and I use headphones over one ear. I'm blind with some peripheral vision and listen to documents via the headphones. Kia ora.
And Alimomo Sandra Alufiwai.
Thank you. Tēnā koutou katoa, whātalo whātul pa ia man malum whain whātasi mai lēnei aso. I am Pacific, I'm of Samoan and Chinese descent, and I too will claim the middle-age bracket for the first time, I think, in all of the hearings. I have shoulder-length, quite curly wild hair, which I have to wear up every now and again. I wear glasses, and today I'm wearing a dark teal dress with red flowers on it. Thank you.
We've had an ageist breakthrough today, and we salute you, Sandra, for your bravery.
I might need a bit of counselling after this, but we'll see.
All right, on that happy note, we now invite you, Ms Anderson, to commence the proceedings for the day. Thank you.
Tēnā koutou katoa. For those listening, I am a further addition to the middle-aged female category. Relatively short. I've got shoulder-length blondish hair. I'm wearing a batik print dress with a white jacket over the top and a shell necklace today. We're just about to hear from Mr Derek Firth, the previous chair, trustee and chair of Dilworth School. So perhaps, Madam Chair, I'll invite you to administer the affirmation, and then Mr Firth has prepared a statement that he would like to commence with.
Thank you. Good morning, Mr Firth, and welcome, warm welcome to the Commission. Thank you for your appearance today. I'll ask you to take the affirmation. Do you solemnly and sincerely truly declare and affirm that the evidence that you will give today to the Commission will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you very much. Just something for you and for any other witnesses who are appearing. It's a matter of timing. We have a stenographer taking every word down. We have 2 signers and we need everybody to be mindful of speed. So if you get stopped, I hope you don't take that as a challenge. It is really just out of deference to our stenographers. Thank you.
Thank you. Derek, are you happy to for me to refer to you as Derek as we have these exchange of questions?
Yes, absolutely.
Thank you. And you've provided a detailed written statement of your own, and you and Mr Wilton have provided a short 2-page summary document, but you've also prepared just a short statement that brings those threads together and the key messages you wish to commence with, and that's what you're going to start with at the moment.
Yes, if I may.
Yes, so I'll hand over to you.
Right, thank you. Madam Chair and Commissioners, I mean no disrespect if I go straight to my statement, but I'll spare you my poor pronunciation. my description, I feel that saying I'm elderly is inadequate, having heard others say the same. But I am an elderly male of European ethnicity, 1.8 metres in height, wearing a dark suit and tie and glasses. This is a supplementary statement to my principal 17 pages of 12 July and the joint 2-page statement of Dr. Wilton and myself of 10 October. And may I start by saying it is obvious, it probably doesn't need to be said, but it is obvious that the sexual abuse at Dilworth was horrible, unforgivable, and caused irreparable harm. I unreservedly join and support the apologies to the victims, and indeed I listened on the live stream to Dr. Wilton yesterday afternoon, and his opening comments could well have been mine. Now, nothing which follows, because I do get into areas that are a tad controversial, but nothing which follows must in any way detract from what I've just said. Now, unfortunately, a number of victims have stated that known abusers were permitted to remain on the staff and that there was a sinister cover-up of sexual abuse within the school. These views may be genuinely held, but they are wrong. No known abuser was ever permitted to remain on the staff, and there was never any sinister cover-up within the school as alleged. There has also been criticism to the effect that known abusers were not reported to the police. Now, you will see from the first page of the 2-page statement that's been referred to, and I've mentioned the witness page there. I don't know if it's appropriate to put that on the screen or not, but anyway, I'll just refer to it. But you'll notice the first page, which is in tabular form, sets out the known abusers at the time that this statement was made on the 10th of October. Now, I should interpolate to say that since then, I have seen a couple of victim statements that have been sent to me, and I think even 1 or 2 other staff members have popped up, sadly. But these are the 12 who were known to us, or me, at the time of the statement. And you'll see that I've listed them down, the years of their abuse, who was the head and chair in each of those periods, when the abuse was reported to the head, the action taken, when it was reported to the police and by whom, and when it was reported to the teaching council. So this one page captures all of that information, and this information is correct. And it is drawn from that information that I carry on. The true position is that throughout the whole of the approximately 40-plus year period, only one known sexual abuser was not immediately reported to the police at the time.
Can I just pause you there, Derek? That 40-year period you're referring to, that's from the period when you first become involved as a trustee through to the period in 2015 when you
Yes.
left your role as chair.
Yes, mid-70s to 2015,
Yep.
yes. That was over 40 years ago, and it was a decision taken on my advice as a new trustee. At the time, the known abuse was of inappropriate touching, and the abuser said he was determined to fight the allegations in court.
And here, Derek, we're referring to the first chaplain.
Yes, the first
That's how
chaplain.
we refer to that person.
Yes,
Yep.
yes. Can I use his name?
No.
No, right. But the first chaplain, yes. He when he was confronted by the then chair the then principal and myself, the three of us. He denied it and said he was determined to fight it in court. I was concerned, having conducted a number of sexual abuse cases as counsel in court, that there was a reasonable possibility that the young victims would not be believed by a jury, and this would be more harmful to them than what they were then reporting. I emphasise than what they were then reporting. It has since transpired that his degree of abuse was greater than was reported to us at that time. Now, under Headmaster Peter Parr, that was the only reported case of sexual abuse of which I am aware, and the only one known to trustees.
And Peter Parr was the headmaster immediately before
Dr.
Mr.
Wilton. Yes,
Mr. Wilton.
That's right. And that first chaplain abuser was later reported to the police by others and prosecuted. Now, under Headmaster Murray Wilton, there were only 2 reported cases of sexual abuse and only 2 known to trustees in his 18 years. Now, can I take the rest of that paragraph as read, because Dr. Wilton covered that in his evidence yesterday afternoon, but there seems to be no need to repeat it.
No, you're right. Thank you.
But it's the way we pull back to only 2 and 18 years who were reported.
And we'll come back in later questioning about what's properly characterised as sexual abuse, because from the discussion with Murray Wilton yesterday, you'll appreciate that there's difference of view about whether what was reported
Yes. And can I
should have
address
been
that?
characterised
Yes, can I
as
address that
sexual
now?
abuse.
Because I think one of the commissioners asked Dr. Wilton whether or not the showering naked with boys by a housemaster was a form of sexual abuse. And of course, today it would seem to be without a doubt. Back in the 70s, it was obviously totally unacceptable conduct. It was not seen to be criminal abuse, and I think Dr. Wilton was advised by the police and 2 other heads that it was not criminal abuse, but to all of us here, of course it was. But that's not how it was perceived at the time in 79, that was.
Although the criminal offence of indecent exposure would have existed at that time.
Oh, yes, of course. Yes, that's true.
Yep.
Yes.
I'll let you continue with your opening
Yes.
statement.
Coming down to the next paragraph, under Headmaster Donald McLean, there was only 1 reported case in his 21 years, and the only one known to trustees. And that was of sexual abuse by a young overseas tutor over 10 years ago. He was summarily dismissed and reported to the police. Chaplain Ross Brown was made to resign in March 2006 for inappropriately encouraging boys to masturbate in class and before any sexual abuse, and I emphasise the next bit, involving direct physical contact, was known. Now, and in my more detailed statement, of course, I cover that in more detail. Now, if, as requested by me on several occasions, Dr. Wilton and I had been briefed by the Dilworth advisors immediately when the extent of abuse was first known, all of this evidence could have been made known to them in December 2019 or early 2020. This would have enabled Dilworth to confidently rebut immediately the false statements to the media about cover-up and about retaining known abusers. And as a result of refusing to comment, the current trustees have, I believe, caused harm to many victims by permitting their wrong assumptions to fester without question. And I think that was an awful thing to have happened. There may have been good reasons, which will be explained in due course, but I cannot think of them. Now, that's the end of my prepared opening statement. I don't know if I'm still within a flexible 10-minute period or not, but may I comment on one or two things that transpired yesterday afternoon?
Yes, do. Please do.
Is that better? Thank you. Mr. Van der Plas, representing a large group of victims, touched on the redress proposed by Dilworth at the moment and the delay with that happening. I totally agree with him that the current proposed redress should have been offered earlier. I think it's caused victims a lot of grief for it not to have been offered earlier. But in fairness to Dilworth, I understand that there were negotiations with the victims group, and that may have protracted the finalisation of that. So it may not be entirely at Dilworth's door that there was that delay. Mr. Van der Plas made what I respectfully suggest was an excellent point when he asked how many victims might have been spared if these early matters had been acted on more appropriately. I think that's the nub of the matter. Madam Chair, you touched on this at the end of the day yesterday, and I think that will end up being the nub of the matter. I totally agree with Dr. Wilton that with those very early cases of offending by the first chaplain and Rex McIntosh, that if we had made a more detailed inquiry of the victims, we may have discovered more and we may have been able to prevent a lot of the subsequent abuse. Now, when I say we, I did not think then and I do not think now that it was appropriate for trustees to interview boys. I think that would have been absolutely wrong. But we could have insisted and required the head and any outside people to come in and better talk with the boys and perhaps get from them more details of the abuse, which seems to have been worse than was reported, and of other victims. So I totally agree with that point. In Mr. Barker's statement, he referred to what the Dilworth Trust Board has now done, and I wish to applaud that to the extent I can, having been approved, the school having been approved through a rigorous Childwise program, having a full-time safety officer, rewriting policies, having an advisory group, and providing for anonymity of reporting. I'm sure there'll be more about that later in the day, but I just want to say that seems to be absolutely right. Now, I don't know whether it's appropriate to comment on Commissioner Eretti's comment, or whether he might ask me the same question later, but I have a comment on a couple of those points, if it's appropriate now.
Why don't we commence with the questioning?
Yes.
And then these aspects might come out, and then at the end, if there's anything that you haven't covered through the questioning that you think you may wish to, then
that would be great. That would be wonderful. Thank you very much.
Derek, you've in fact been very keen to have your opportunity to present at the Royal Commission and to have your witness statements, including your long and the two-page short form, publicly available, haven't you?
Yes, I have.
And you've expressed in that documentation, perhaps that one of your driving concerns is that you felt a bit shut out of what the current Trust Board process is, and that you don't feel that they've put the right messages into the public domain. Is that accurate?
Only in the two issues that I've referred to. I think everything else has been excellent. But on those two issues of, well, on the issue of just staying silent when the victims were festering, and I think in my statement I say like an unlanced boil, they were allowed to fester over these things were not correct, and they were not being corrected, so they just got greater entrenched in their minds. So for the last year, 18 months or even more, the victims have been unnecessarily stirred up over a lack of reaction to those allegations. And I'm not suggesting that the victims should agree with me or agree with what we did. I'm not suggesting that they will think what we did was right. But what they were yearning for was some explanation, and they never got it. And that annoyed me.
Mm. And I think that comes across quite clearly in your statement. The one-page summary table document that you and Dr. Wilton prepared, I'm not calling it up, but I'm just talking about the nature of it. Is it accurate to describe that what you've listed in there includes reports that were known to you through your role on the board? Is that right?
No, some of this material I only learned when it came forward as a result of the police inquiry or this inquiry.
Right, so, but it includes, you'd be able to identify from the list here those that you were aware of at the relevant time.
Well, just going very quickly, I think, yes, I've got the redacted version,
Yeah.
but just going extremely quickly through them. Stevens, back in 71, never heard about him until a week or two ago.
Right. But let's just go through and the ones that you do. So that second one, Dixon, you were aware of that during your time on the board?
Sorry, from 75 on, the school chaplain would be the first from my time on the board.
Right, the first for you. Okay.
And I knew within hours or a day of those complaints being received.
And you knew about Macintosh?
Yes, in fact, I think Dr. Wilton said in his detailed statement that he and the chair, who would have been Bill Cotter, confronted Macintosh. I'm quite sure it was Dr. Wilton and myself who confronted Rex
But
Macintosh.
you recall involvement with that?
Absolutely.
And clearly you were aware in terms of involvement with Ian Wilson in 96?
Yes.
And with Mr. Wynyard?
Wynyard, yes. Now, I'm not sure that I knew much about him. I think it's the sort of thing that would have been reported to the board, and I must have known about that at the time.
And Cave, you would have known at the time?
The same, yes.
Yeah.
Yes.
And then the next person listed as the housemaster, would that have been something you knew about during your time on the board?
Well, I must have. I just need to look at the unredacted copy just to remind myself of who it is. Yes, no,
It relates to a 2018 report, so after your time on the board, so
yes.
unlikely
Oh,
that
yes. Yes, I don't recall him being reported.
Yeah.
But
and the next one's the 1994 report by the person.
yes, I certainly
Yeah, you knew about that.
remember that person.
And the next one says not reported until much later in time.
No, that's right.
And then the second chaplain, Ross Brown, you clearly knew about that.
Yes, yes, and picking up the point the Commissioner made about showering naked with boys should perhaps be considered as sexual abuse. one might well say exactly the same about encouraging boys to masturbate in class. I mean, it was appalling.
Absolutely.
Just appalling.
Absolutely.
But that's why I referred in my brief statement to the events that resulted in direct physical sexual contact.
Yes, and I think we'll come back to that, Derek, because I think there probably has been an understanding in the decision makers in the school that perhaps that only if something were required that had involved that physical contact that it was properly characterised as sexual abuse.
Yes, I'm not sure it's as simple as that, because we regarded the showering naked with boys as appalling. We regarded the encouragement of the activity in class as appalling.
Yes,
And
but still
yeah.
not necessarily conceptualising of that activity as sexual abuse at the time.
We probably did not see it as criminal sexual abuse.
And that last tutor on that page, that would be somebody that you would have been aware of.
Oh, yes.
Yeah.
In fact, I should make it clear that despite a lot of press, well, I'm not blaming the press, but as a result of statements that have been made, my understanding, and I think it's a fairly reliable one, is that this last young tutor, who's last on the list, was the only offender who actually raped a boy. Now, if that had happened earlier, there was no hint of it in any of what was reported to us. So
Well,
I'm not saying
yeah.
I'm not saying it didn't happen. I'm saying that if it did, it was not reported to us. This was the only conduct amounting to rape that was ever reported to us.
In terms of the dynamic between the board and the headmaster, so the operational arm under the headmaster and the governance at the board level, do you agree that you'd be very reliant on what was escalated up to the board in terms of what you were told about reports of abuse at the school?
Yes, of course. I mean, the trustees didn't get involved with the house activity routines or...
No, but you'd expect to, and Mr Wilton was very clear that all reports of abuse were advised to the board.
Yes, and I'm sure they were.
And when you've come and make the statement that there was no cover-up, you're really relying on what you as a board member knew at the time and the actions you say were taken as a consequence of that knowledge. Is that right?
Yes, that is. And just in my whole career, I tell witnesses never to try and think where the questioning is going. But where that might well be leading to, I think, is this, that there may well have been other students who covered up, so to speak, or who did not mention it, and there may have been one or two junior staff members who did not mention it when they should have. I understand that, but yes, we relied on what the head reported to us, because we did not have any direct reporting line with any other staff member.
That's right. So from a governance perspective, you need to know that your systems and policies are appropriate and the right information is coming up to you.
Yes.
Yep. And your risk management includes making sure that that happens.
Yes.
Now, I think you're aware that a number of survivors say that they disclosed reports of abuse to different staff members and sometimes to the head, and that they weren't believed, and in fact at times they were disciplined. You're aware that that's what some of the survivors say?
Oh, absolutely. In fact, I understand 2 boys were caned for reporting abuse, which is...
Can you tell us about, I think that's referred to as the caning incident, isn't it?
Well, I thought there might have been 2, but 1 or 2.
1 or 2. Can you tell us about those?
I don't really know much about them, except that I heard that this had happened.
At about what kind of era? 70s, 80s?
Oh no, back in the late 70s, because caning was abolished in the very early 80s. So it would have been the late 70s or very early 80s. And I'm not sure of his title, but he was, I think, like the head of the junior school, a chap called Burnett. I think did that. I'm not sure if anyone else did. And all I can say is it was appalling, but that reflected the view of that staff member at the time.
That's right, but also a systems failure, because that information hasn't come up to the board, has it, that somebody's reported abuse?
No,
It's simply because they actually haven't been believed and they've been punished.
Well, that never reached the board at the time.
Yeah.
I would be reluctant to call it a systems failure, but it never got to the board, that's true.
Yeah, but your system's designed to make sure that all reports of abuse come up to the board so you can take appropriate, yeah.
Absolutely, that
And
is
if
the
that system
intention.
doesn't work as intended, that's a breakdown of the system, isn't it?
Yes, of course that's a breakdown in the system. But whether it's a breakdown that one could easily guard against or not, I'm not sure.
And so at the board level, there might be various of these incidents of boys reporting abuse and getting a punitive response that the board's just simply unaware of.
Yes, that's true.
Yeah.
I'd like to think there were not too many.
Yeah. And do you accept that for those survivors who have come forward and said that that was their experience, that they consider it can be fairly characterised as a cover-up because no action was actually taken to prevent the person they were saying was harming them from going on to harm other people?
No, I think that where a complainant was not believed, even if wrongly not believed, that's not correct to call that a cover-up. I think it could only be rightly called a cover-up if it was known and accepted to have been abuse that was then concealed.
Well, that requires, doesn't it, quite a few steps, because that would require an investigation into the allegation, wouldn't it?
Yes, but if a staff member receives a complaint and doesn't believe it, and wrongly doesn't believe it, that's not the sort of thing that would ever normally go further.
Well, we can agree that it wouldn't normally go further. I think the point we're disagreeing on is that you don't accept that from a survivor's perspective that that's a cover-up of the abuse that was occurring at the time.
Sorry, I'm a bit slow, and I've got the point. Yes, I can certainly understand survivors thinking that was a cover-up.
And that perhaps that might have influenced, knowledge of those sorts of events might have influenced the school of not wanting to go out publicly and deny that there had ever been any cover-up, in the way that you and Dr. Wilton have been quite keen that the messaging should have been.
Yes, I'm not quite following the point, Ms. Anderson.
Well, your very strong point in your evidence is that there's no cover-up, that's right, isn't it?
Correct.
And you say the messaging from the current school board should have been publicly that there was no cover-up. That's what you say they should have gone out and said, and that would have prevented further harm to the survivors.
Yes, had the position of myself and the current board been reversed, I would have insisted on it.
But can you see the danger of going out and saying there's no cover-up while there may be instances from a survivor's perspective that they've reported abuse and been disbelieved, and that they consider that that is in fact a cover-up?
Yes, I can see it would have been helpful to have a bit of a clearer understanding of what was or was not a cover-up. What I and I believe Dr. Wilton is saying is that no known abuse, no accepted or no believed abuse was ever covered up.
That's right, but I think we can further confine that, can't we, to no abuse that the board was aware of? Because there seem to be reports of abuse to various people in the school environment over time that were never came up to the board because the reaction was disbelief and punishment in some instances.
Yes, but every complaint had to be addressed in some way. I mean, there was at least one case where a boy complained to the police and then withdrew and said he'd been lying. Now, you know, that's why the staff had to be careful and look into each complaint. Now, I'm not doubting for a minute what's being claimed by these survivors. It's just terrible. And I'm not doubting the accuracy of that for a moment. But I would fully support the staff questioning it when it was raised. I mean, they had to make sure they were being told the truth. And in my case, I was going a step further with the first chaplain and those complaints, and I was focusing on whether or not a jury might accept their evidence if it was contested. And incidentally, if I can add to that point, there's a respected lawyer in Auckland whose name's prominent, Sonia Cooper, who specialises in this area. And some years later, Sonia Cooper wrote to the board on behalf of a victim whose abuser had been reported to the police. And Sonia Cooper, an expert in this area, complained to the board, I think while I was still on it, complained to the board that it had complained to the police without the victim's consent, for the reason that it can be a terrible process and can rebound against the victim. They were Ms. Cooper's reasons for writing to the board about a totally unrelated matter, and that reflected exactly my reason back in 1978 with the first chaplain.
Can I just, Mr. Firth, can I just take you back to the question of the staff receiving complaints and not
Yes.
acting on them? Because I
Yes.
think that's what we're aiming on here.
Yes.
Was it the board's policy or the school policy that a teacher who received any complaint of misbehaviour by other staff should deal with it unilaterally on their own without reference to anybody else?
No, there would not have been a policy to that effect at the time.
So when you say that a staff member has received a complaint and hasn't done anything because they didn't believe them, that is effectively a staff member acting unilaterally, isn't it?
Yes, and that was wrong.
That's right. And I think that's the point, that when boys brought complaints to staff members and the staff member dismissed them out of hand or didn't believe them for however well they justified they felt, that was not a proper action on the staff behaviour, and it deprived the board of the opportunity to properly investigate.
Yes, absolutely. I would like to think that was a pretty rare sort of thing, but I agree entirely.
Right, and I think that's probably where we get to. Was it rare? Or did it happen, etc.? Thank you, Ms. Anderson.
Thank you, Madam Chair. So turning to the first chaplain, which is the example in which you say that there was a thorough investigation carried out, and I think you also say...
Yeah, I'm not sure about thorough. There was an investigation. Mr. Parr was certainly asked to inquire. I specifically asked Mr. Parr if there were any allegations involving penetration or oral sex, and he specifically asked that of what he told me, that he asked that of the complainants and that there were none. Now, the complainants may well have been more abused than they reported, and I'm not criticising that. All I'm saying is that that is what was reported back to Mr. Parr on those specific issues which I asked him to inquire about, and there were no complaints to him of that degree of activity.
And we don't have records of that investigation, do we? Because it appears that those, as you will have heard in the discussion with Mr Wilton yesterday, there's a document recording
Yes,
that in 92 or 93 the documents were destroyed in a clean-out.
yes, and I heard that and watched that yesterday, and I was aware that that had happened, and that was the last thing we would have wanted to have happened. When eventually the board caught up with the fact that these older documents had been destroyed, we were annoyed. We had not wanted that. We did not want it. I wish they were available, and that was a unilateral action by the then general manager, who obviously thought he was doing the right thing by having a clean-out, but it was not right, and he should not have.
Not in accordance with any board policy on document retention at the time.
No, in fact, I'm very familiar with the concept of document retention. And advised a number of organisations on it, including the tobacco industry of all people. So I'm very familiar with this notion of document retention policies. But we had, as far as we were concerned, it was left to the discretion of the general manager. We did not have a document retention policy in those days. That expression, document retention, is, of course, sometimes euphemistic for a document destruction policy. But we had no policy of any kind involving documents. It was left to the discretion of the general manager, but I could not believe that he thought it inappropriate to keep those documents.
And
Destroy
from
them,
your
rather.
knowledge of the investigation, because from what we've seen, it doesn't appear that there was a great attempt to reach out to boys who, because the chaplain had contact with a wide range of boys
Yes.
at the school, to go very broadly to work out who might need to be approached to see whether they had been harmed.
Absolutely, and that was a very, very unfortunate failure. We felt that we were doing the right thing by asking the principal, the head, to do what he did, but in view of the way things have turned out and what we now know, that was absolutely wrong and unfortunate. It looks quite clear now that if we had had either Mr. Parr or an outside person to give more comfort to the boys, that if we had had someone make more inquiry of the boys, that may well have led to more information of other victims and other kinds of offending.
And might have influenced actions taken in relation to the activities of that chaplain in the community after he departed Dilworth.
Yes, probably, or possibly would have, depending on what it had led to.
Yeah.
In that particular case, we felt, rightly or wrongly at the time, that reporting him to the bishop was a pretty huge sanction. It seems to have not been the case.
And in fact, you later learned, didn't you, that excuse me, the chaplain there'd been a glowing communication relating to the chaplain before he came to the school, but you later found out that there'd been allegations that he'd abused others in a different place before he came to Dilworth. Do you recall that?
Yes. We're getting into second or third round of hearsay, which I presume is permissible.
Sky's the limit in this commission.
Yes. So on that basis, yes, it is hearsay. But Peter Parr, who was the head, made inquiries of this chaplain's former employment was in a cathedral in the South Island, and he was told that this chaplain had abused choir boys in that cathedral.
Just a moment. Miss Guy Kidd is on her feet. Yes, Miss Guy.
If I could just indicate just the factual matters that have been brought out already. show the risks of dealing with hearsay. This chaplain was never in a cathedral, never worked in a cathedral. So
Right. Then that's a salutary reminder. Thank you, Ms. Guy-Kidd.
I'm sorry,
So, Mr. Firth,
that's not right.
well, just to be, we won't start toing and froing. I think these are, and because we are a commission, we can tidy these matters up afterwards and get to the bottom of it. But the danger, of course, here is a reputation natural justice issue that, you know, can't be answered in the context. So for that reason, this is not a cover-up, but this is a protection for people who need an opportunity to respond, and they will get that. So I think if we can just be very careful that you can tell us what you heard, but if you could just refrain from mentioning names, institutions, organisations who might be negatively impacted and need an opportunity to respond. Does that make sense to you?
Absolutely. And Madam Chair, if I can perhaps confine it to this, which hopefully won't cause too much disturbance.
Yes.
This chaplain came to us, and his application form and his details set out that he had been at a cathedral in the South Island.
Well,
Now,
let's not repeat the thing. He'd been at other
wasn't.
institutions. If we can just leave it at that
All right,
point.
but if he wasn't, then that was something false in his
Okay,
application.
all right.
Because as I pointed out in my more detailed statement, the trustees of Dilworth make only 2 direct appointments, the headmaster and the chaplain. They're the only 2 direct appointments that the trustees ever make.
Yeah.
Derek, in terms of a comment that you've made in an email in 2021 that you provided professional counselling to the boys in relation to this complaints in relation to the chaplain, and is it your recollection that that was counselling to the 2 boys who'd come forward? It's not to be interpreted as you provided counselling generally to boys who might have been harmed by this chaplain at the school.
Well, we asked Peter Parr to arrange counselling for boys who had been molested by this chaplain.
But you didn't have a wide investigation to find out how many, did you? So you were
Yes,
just
well,
dealing with those
yes,
that had come forward.
At the time, he told us who the boys were, but I cannot remember now how many.
Do you,
So
do
there
you
would have
recall
been-
Neil Harding's evidence in the witness bundle that you've looked at?
Yes, I read his evidence twice.
Yeah. And of course, he says that he was abused by the chaplain, but no one ever approached him to find out whether he'd been abused by the chaplain.
Yes, and I don't doubt for a moment that would be true. If he was one who complained to Peter Parr, then...
Well, that's my point of distinction. You know, were you dealing only with people who proactively came forward and reported the abuse, or were you looking at, and I think you've conceded that there should have been but wasn't, a wider investigation into who else might have been harmed by that chaplain?
Yes. We only spoke to Peter Parr about the boys he said he was aware of.
Okay.
Now,
Okay.
I've agreed earlier that we should have asked Peter Parr or some outside person to come in and see if there were more victims.
Yes. Just going to move on to the second chaplain, Ross Brown, whose name we can use.
Yes.
Going to take you to a document which is TGC 0000514.
Is that popping up?
It'll come up on the screen. While it's coming up, Derek, I'll just orientate you to it. It's a New Zealand Police job sheet in 2001, and it relates to possible possession of objectionable material. Do you see that on the middle of that first page?
Yes, I do.
And then we're going to turn over to page 2. And we can see, can we just call up and
Sorry, we've had to pause the live stream evidence We'll be back in a few minutes. Sorry, we've had to pause the live stream evidence. We'll be back in a few minutes. Sorry, we've had to pause the live stream evidence. We'll be back in a few minutes. Sorry, we've had to pause the live stream evidence. We'll be back in a few minutes.
Met with to leave, I'm fairly certain this was an incident where he told a foul joke to a group of boys, and that led to this complaint.
So by foul you mean a sexually explicit
Oh, it was
joke?
I can't remember it and wouldn't want to. It was absolutely awful.
So again, an incident of that would have been of concern, but you're saying the board didn't know about this at the time. Is that what you're saying?
Yes, that's correct. Yes.
So again, it looks like the system's just not working properly, is it? That things that are significant enough to write to the bishop about are not coming to the board.
Yes, I'm slightly resisting, but I don't want to be defensive about it, but I'm slightly resisting this regular reference to systems. The particular rule, as I mentioned in my detailed evidence, was that with both principals, they were well aware that the board expected no surprises. And that was a very simple way of saying we did not want to be taken by surprise ever. One of our trustees during part of this period was a director of the owner of the Herald. And he often used to say to us, whatever we do or don't do, we've got to assume it might end up on the front page of the Herald. He was a flipping director of the publication, and we were constantly vigilant to avoid that sort of thing. So the two principals were under very strict instructions that we did not ever want to be taken by surprise.
So those expectations were very clear, weren't they?
They were clear, but I really, if I may, Madam Chair, follow this with a very quick comment, because things could get out of proportion. Dr. Wilton and Mr. McLean were exemplary headmasters in my view, and I'm very unhappy at their reputations being tarnished in this way when they were when they were unquestionably doing what they thought was best for the school. And I just hope that's not overlooked in this whole process.
Yeah, and I'm not asking the questions from that perspective. I'm asking about the expectation about how the reporting up would work, and whether this is an example of that expectation. Your word, I'd use a system word, but you're using expectation, that hasn't, your expectation hasn't been met in relation to something as significant that required a letter to the bishop.
Yes, I would have expected to have been warned of something of this nature.
And then a couple of years further on in the sequence, so that was 2003 we were looking at, so 2 years later, June 2005, calling up DSW 0000104. So just while this is coming up, Derek, it's a letter from Principal McLean to Ross Brown in June 2005. And you'll see in the fourth paragraph, there's an allegation that the chaplain was allowing the students to sit on his knee. And at the bottom of the page, some other allegations that are not very clear, but which are described as a blurring of boundaries between the group of students and the chaplain. And then over the page, we see that there's recording on the file. We'll just bring that second page up so you can see. Recording on the file a strong caution with regard to the specific instance discussed.
Yes, I don't remember the particular letter, but I was certainly involved at this point.
So in 2005, you're aware
Yes.
of this because it's leading to a sanction, a formal sanction on the
Absolutely.
staff member record.
Yes.
And then we know, don't we, that Ross Brown's resignation is in March 2006.
Yes.
After the incident that you've described in your opening statement of encouraging boys to masturbate in class.
Yes, I think we were aware of that, I think, the previous year in 2005.
Well, certainly I think Ross Brown's letter, we won't take the time to come up to it, but accords with that because he's contemplated the position over the Christmas break.
Yes. We had a lengthy period of discord with Ross Brown. I don't know what expression to use, but he had the gift of the gab. And he was adamant that everything he was doing was consistent with proper educational instruction and not causing harm and so on. And Donald McLean and I and the other trustees were equally adamant that he was going off the rails. And we were very, very unhappy about it. Now, I'm sure back in 2005 we were taking legal advice from our lawyer, who was an employment expert, and we were advised that we had to be very careful because he was denying wrongdoing. The lawyer pointed out the need for notice and warnings and all those well-known things, and we were well at a point before Christmas in 2005 that we were very unhappy with this chap, uneasy about him, and wanted him to go. And we were getting legal advice at the time.
And was he stood down over this period that you've got this concern and you're engaging with lawyers?
I don't remember him being stood down, no.
Not stood down.
No, and we would have been advised against that. you see, at the moment, now, we know that he crossed the boundary in a horrible criminal way. We had no idea of those events that eventually led to his conviction. We were only aware of these sorts of things, like having boys sit on his knee and encourage them to masturbate in class, which were appalling. I mean, absolutely appalling.
Well, significant red flags, weren't they?
Absolutely.
Yeah.
Absolutely. And so really from whenever we were aware of that in 2005 through to persuading him to go in March 2006, and I was actively involved in that directly, we were getting constant legal advice. There'd been meetings with him. I think there might have been one or two with his legal representative present. I mean...
Yeah, so quite a process.
He was shaping up for a fight.
Yeah.
Yes.
And so then in that context, that's where a resignation is accepted rather than dismissal of him from the staff. That's right?
Yes, yes, that's right. Well,
And, and we've heard Dr...
Sorry.
You go.
I think it was apparent to him that if he didn't resign, he would have been dismissed.
Yes, but it's still, I mean, we've had a trend of persons who've been accused of abuse, not just at Dilworth and a lot of other institutions where the option of a resignation and moving on happens rather than a formal disciplinary process. And that's what's happened here, isn't it?
But we were advised that he had not committed an offence for which he could be summarily dismissed. Now, I'm far from confident that was the right advice, and I said so at the time to our advisor, but that was the advice.
And does that, Derek, does that relate to, the basis of the information that you've got is really what's people have come forward and reported, as opposed to a wider investigation of what actually might have been the harm this chaplain had been inflicting in the school? So you were on the subcommittee that did the investigation, weren't you?
Yes.
Yep. And that investigation report, I'm not going to bring it up, but I think they spoke to 8 boys who'd come forward. They spoke to 8 boys in that investigation.
I don't remember us speaking with boys directly. That would surprise me, but I don't remember that.
I don't think the board spoke to them directly, but the person carrying out the investigation.
It would have been Mr. McLean.
Yeah. And no calling in an independent person to investigate at this point. That didn't occur to the board as an option. And so again, sort of decisions made on, a certain pool of information, but had there been an investigation, there might have been much more information available to the board at this time.
Well, looking back now on the horrible things he was doing, yes, I guess if there had been some sort of wider investigation, they would have emerged and boys saved from the terrible things he was doing. But no excuse for him. I mean, but we believed we were following the right process because, as you will well know, 80% of employment law is getting the process right. Mm. And as most employers know, that drives them mad. So we just had to comply with the law as we were advised by an expert in employment law. Our advisor is now a judge.
You see, you will have heard Mr. Wilton yesterday. I think he conceded that by 1996, with all of the information available at that time, leading with the point in time of Ian Wilson, that could legitimately have been a point in time that the board could have commissioned a wider inquiry of the type that has been commissioned in 2021 about the nature and extent of abuse at the school.
No, I think
The question I'm putting...
I think that's easy to conclude now. But if you look at my opening statement now, there was one case of known abuse, known to me anyway, of Mr. Parr, 2 in the case of Dr. Wilton over 18 years, and 1 in the case of Mr. McLean.
But that's partly how you characterise what is the actual sexual abuse, though, isn't it? In terms
That would add 1 or 2 at the most to those numbers.
Yeah. So you don't accept that there's a point of time, either in 1996 or moving forward 20 years to 2006, in relation to Ross Brown, where it's a point in time in which you've known that 2 chaplains his conduct has been highly questionable in the school environment. So thinking about 2006, with the history leading up to that point, my question to you is, did the board ask itself at that time, is there a problem that we actually need to do some work to understand the nature and extent of it?
No, when I was chair at the time, and it was not considered or discussed. All I can do is repeat those numbers, give or take 1, depending on definition of abuse, over 18 and 21 years, 39 years. There were 3 or 4, depending on that definition. It wasn't a setting in which we saw the need for that sort of wider investigation. Now compare that with the last couple of years, with Operation Beverley. All the information has come to light, all the complaints that have come to light, all the prosecutions that have come to light. It's a different world, a totally different scene. To think that we might have been in that setting in 2006 is just not right.
Do you accept that in Operation Beverley, one of the different features was that the name of the school was put out in the public domain?
Yes, and I've certainly...
Commissioner's time for questions, and it relates to an exchange of letters that you're familiar with from the bundle between yourself and Frances Joychild and the person that she was representing back beginning in December 2012. You recall the documents that I'm talking about?
Just about memorised them.
Yes, yeah, so we won't need to bring them up. I'll call out, so read into the record, and then we'll give you an opportunity to respond. You've written a letter to Ms. Joychild in January 2013, just so that we've got it in the transcript reference. The document number is DWS 0001984. And you're saying that you are happy to meet with her client, but that you intend to do nothing is nothing more than a courtesy. Do you recall that language? And then you say you will appreciate that one has to be very careful about historical complaints because, first bullet point, many cannot be authenticated because of the passage of time. Second bullet point, we are informed that a relatively high proportion tend to be made late as an excuse for difficulties which have arisen in the person's life. This is not to say that the abuse does not occur. And then your third bullet point, we are informed that a number of late complaints are motivated by an intention to seek accident compensation. You go on to say, I do not intend to offend this person by these remarks, but simply state the factual context in which we must consider what is being said. And then you go on to say the Trust Board will not make any financial contribution to this person's travel costs to meet or the legal costs, as it would be quite inappropriate to do so. And then you say, I also signal that that the board will not make any other payment of any kind to this person. So you recall this correspondence, yeah. In terms of a survivor being given a copy of your letter, Ms. Joychild would have been required to share that with her client. what do you say about the harshness, my word, harshness, of the propositions that you've put forward as in this letter?
If I had any inkling then of what I know now, I would never have said those things. May I add a bit more?
Yes.
Yes. At the time, it's absolutely true. There had been coverage in the media of the ACC paying out $10,000 as a blanket figure to male and female victims of sexual abuse. And the point of some coverage was to the effect that the ACC was getting wary of this about the veracity of some of these complaints. So that was absolutely true, but it wasn't an appropriate thing to say, obviously, and I shouldn't have said it, but it was true.
But
Yeah.
the point that people make complaints late as an excuse for difficulties that have arisen in the person's life, do you think that perhaps clearly doesn't illustrate an understanding of the impact of trauma on someone's life?
I totally agree. If I knew now what I knew then, I would not have said that.
What's the message that you might want to give the survivor today about your statements in that letter?
Well, it led, the publication of that letter by the Herald led to a complaint to the New Zealand Law Society. And
I know I've asked you about what you want to say to the survivor.
well, I'm sure that my response to the Law Society would have gone to the survivor. And in it, I made exactly these points that I would not have said those
Excuse
things.
me, I just want to, I understand that this evidence may well and is obviously upsetting and triggering to many people. But the Commission's not helped by noises off and it's interrupting the flow of our concentration. If you want us to listen carefully, analyse carefully what's being said, please don't interrupt. And if you feel you need to express yourself loudly, please do it outside so that it doesn't interrupt our ability to concentrate on the evidence, because it's doing that now. Thank you.
Well, the short answer to your question is that I wish I had not written that letter, and I'm sorry. But that point's been well and truly made before now, and to everyone concerned.
Do you think the mindset that you had when you wrote these words, which is a decade ago, so relatively proximate in time, and at a time when you were chair of the board, is reflective that there was a culture of disbelief of what survivors were saying at that time in 2013?
No, I just think it reflected my age and my view of the world at that time.
You did say that you had some comments that you wanted to make, further comments. I don't think we've covered perhaps your opening statements that you wish to make in relation to a matter Commissioner Eruiti had raised with you yesterday, perhaps.
Well,
Is there anything else that you wish to cover before we open up for questions from the Commissioners?
No.
Thank you, Ms Anderson. I'll just ask my colleagues if they have any questions. Paul, do you have some questions?
Thanks, Mr. Firth. Just clarify for me, you made the comment about around the board, the advice given about not wanting to end up on the front cover of the Herald, and I wasn't sure whether the context of that was you thought that was a kind of safeguarding against potential cover-up, or that was advice that might advise that we want to cover up.
Oh, no. I'm delighted to clarify that. This was in the context of all of the board's undertakings. It's commercial undertakings, property undertakings, dealing with lessees, not just abuse. In fact, I don't think abuse was even being thought of when those comments were discussed. It was just very wise advice from a very wise trustee to say that when anyone doing anything is deciding whether to do something or not, they should give thought to not wanting it widely published, just because it would be a silly thing to have done. It had nothing to do with abuse. It was just a generalised, wise comment, and I think it was probably more in relation to our commercial activities.
There's a lot of wise advice, wise trustees. You made the comment about your age and view of the world. Would it be fair to say that there might not have been a lot of diversity amongst the board in terms of their age and views of the world?
Yes, well, there was certainly no gender diversity because the only woman trustee was Mrs. Dilworth. Until very recently, there's been a woman trustee. But in my time, there was no gender diversity. There was no ethnic diversity in my time. But there was considerable diversity in experience. And I mean, the trustees in my time, many of them were chief executives of very, very large organisations.
But that wasn't enough to understand what was going on in the school and to safeguard boys within the school. Would that be fair to say?
Yes, it would be fair to say, because the trustees did not... the trustees saw the most important appointment they made, the two most important appointments they ever made were the general manager of the trust board and the head of the school. And as in all good corporate governance practice, one is expected to let those people drive their relevant areas. I think it's well known that many organisations go off the rails when directors or trustees try and get involved in the detail.
I'm wondering about the culture of the school and what the board projects. I think you've expressed, in some cases, quite adamant about what you thought happened or didn't happen, and recognising the power that boards have and the culture it projects. Could you imagine, or did this sort of go through the school? I'm just imagining how hard if you're a boy at the school wanting to say something and there was this adamancy about what has or hadn't happened. Do you think that would have made it hard for boys to report abuse?
Well, certainly boys would not have come direct to the trust board while they were students. That would not have been encouraged, and I don't think it would have dawned on any of them to do that. But I can't see why they should have felt daunted about talking to staff about any topic.
But I suppose, could the adamancy of the board sort of project the point of punitiveness that if somebody was to challenge,
No.
that there'd be canings and things like that?
No. It would come back to the approachability of the staff, and their approachability would not have been influenced by the board. They would be wanting to be good educators.
Okay, thanks.
I'm sorry if I've come across as being adamant.
Well, no, it's important we hear your views, Mr. Firth, and that's the whole point about this hearing, that we're hearing the perspective of boards, of the governors at the time, and it's important we hear those and hear them well. Sandra.
Good morning, Mr. Firth. Thank you for the views that you've shared this morning. I'm still just a little bit troubled, and I'm hoping you'll be able to clarify this for me. Given that the board was made up of so many esteemed members and there was so much legal advice, including your own standing, about the concept of abuse, be it at the very worst that we've seen, at the sexual end, right down to bullying and harassment at perhaps a lower end, depending on the circumstances. And the stance that the board took really in terms of all of the advice that was coming in around the circumstances in which you were seeking the advice, like Ross Brown, and how you weren't able to marry that with what you were seeing in your practice. So you refer to your own background, and I'm really just wanting to understand, I suppose, what was going on in the school, what you were seeing out in practice, like what was happening at some of the other schools that you're involved with, but also with some of the other bigger communities that you're involved in prosecuting, Centrepoint. How you weren't able to perhaps draw a stronger thread between what was happening at your school and what was happening, the reality of the context of the day.
Yes, that's a very good question, and looking back, of course, there should have been more red flags, but I would invite you to focus on how it was presenting itself to us at the time, because it was a much fewer cases of abuse over a very long period. That's all been concentrated into a tsunami of abuse now. But at the time, these were one-off things widely spread out. And I can assure the Commission that there are only 6 trustees. We were very hard-nosed in business, which is obvious for other reasons. And we were very hard-nosed with ensuring that the school did the best it could for the boys and their families. Now, that was what we intended, that's what we wanted to do, and if you put abuse to one side and consider other risks, like risks of fire, risks of vehicle accidents, all sorts of, there's a myriad of other risks, as you would know. And we were vigilant in respect of all of them. I mean, we had the buildings, we had remedial work done to the buildings to make them safer from fire, from window breakages, from all sorts of things. We were focused on a very wide range of risks and addressing them all. And if anything cropped up or came to our attention that indicated we were lacking in addressing these risks properly, we jumped on them. And it was pretty heavy jumping. And similarly, when abuse was reported, we jumped on it. We were, any other approach would have just been wrong. So I would ask you to see what we were doing and how we were addressing things in that broader context of all risks.
Yeah, that's accepted in terms of the evidence that's been filed. It's been very, very full. But there is a line in the evidence which constantly refers to the vulnerability of the boys that were coming to the school, that it was more than just good works, that there was a nurturing that the school was seeking to do. You've turned out prime ministers, you've turned out politicians, you've turned out exceptional businessmen. But there was also this other underlying vulnerability that was coming through just as strongly, and I guess I'm just wanting to ask now to give you the opportunity, and this is the beauty of hindsight, the reflection that perhaps there was a gap there in the thinking around that board table, around the psychological protection that enabled children and young people, because what the research tells us is that on average it takes about 20 years before a young person, a young boy or a young girl, can actually find the courage to speak up. So there's a parental responsibility in a sense.
I totally understand that now. I certainly did not understand it in the 70s and 80s. And I think it is fair to say that in the late 70s, from my involvement, through into perhaps the mid 80s, there was a lack of nurturing. I think that's the right word. There was a lack of nurturing, and that probably was reflected in how, or the lack of detailed attention that was given to victims. Because we simply said to the heads, make sure they get counselling. I mean, to our minds in those years, that's what you did. But we can see now that's totally inadequate.
Thank you, Mr. Firth.
Mr. Firth, tēnā koe. So, yeah, following from my colleagues' questions, I noticed you said in your evidence your resistance to the idea of systemic problems with governance. And I wonder if you still hold that. It seems from listening to the evidence, looking at the brief, that there are these gaps in terms of providing the necessary safeguards, in terms of vetting of staff and providing an environment where these vulnerable students would feel confident to come and disclose abuse. And your position is a position of enormous responsibility along with the other trustees. So I wonder, just reflecting on that, about whether you think that the systems could have been more robust, which would have enabled the complaints to filter through to the trustees during your time at the helm.
Yes, I come back, rightly or wrongly, but I come back to the fact that we required the heads to have the right systems in place as they were understood at the time. And of course they were in constant touch with their counterparts in other state and independent schools. So they were not bringing to Dilworth their personal views only. They were bringing to Dilworth what they had learned through consultation with their own peers in the education world. I don't think for a minute, and I'd say so if this wasn't the case, but I don't think for a minute that the trustees instilled or suggested or influenced amongst the heads any form of view that they should be resisting a welcoming approach from students. In other words, that's anathema to what we would have felt had to be the case. The students had to feel they could speak. Now, back in the 70s, there was an incredible level of discipline, as you've read in the statements, which was not appropriate and was discontinued. But there was of this disciplined atmosphere in which the boys were brought up, and that could well have had the effect of making them reluctant to come forward, or come forward in the case of the first chaplain with the full details. On systems generally, may I make a comment on protocols, because I think the whole world's been sent into a tiz with having the right protocols, and I respectfully suggest that there's an angle to that that can helpfully be addressed. If you think about yourselves and others who have engaged babysitters, I don't think anyone has ever said to the babysitter on arriving at the doorstep, "It's a rule of this house that you must not sexually abuse my children." I mean, you wouldn't even think to say that, would you? How many babysitters in the world, how many parents in the world or caregivers would say that to their babysitters? I suggest probably none. So similarly, there's not much point or reason in having in a protocol a statement that you must not sexually abuse the boys? I mean, for the same reason, you don't tell babysitters that when they turn up at the door. But from an employment law perspective, it is important to now have that in those protocols, not because that will stop it happening, but because they know that under employment law, it will be instant dismissal. I cannot follow the reasoning that a rule book that says you must not abuse the students is going to have the effect of stopping any abuse, just as parents don't say that to babysitters.
You do vet your babysitter. You do
Oh,
check with other parents to say, you know, that, can you trust this person?
Absolutely.
You do call in on your iPhone to, you know, to check to make sure that with
Yes.
the kids who have phones these days, there is oversight. There are systems in place, but it does not seem that, for example, to be trustees, that is a really significant place for oversight and monitoring of the behaviour within the school, including the heads. And it seems as if that responsibility was kind of really left with the heads, and then just assumed by virtue of their character and experience that they would do that monitoring oversight role. Would you say that's fair?
Not quite. Not quite, because with the more senior appointment, well, that is certainly fair with the more junior appointments, which is where these problems arose with the more junior appointments. So what you have said, Commissioner, is right. It was left to the heads. With the more senior staff appointments, the heads would always come to the board or the chair and say, look, we're down to these three. What do you think of them? So although the decision was the heads, the chair or the board would be consulted on the last few. But that did not happen with the more junior appointments, and it's the more junior staff members. Well, initially it was the more junior staff members who were the problem, although the chaplain, this blessed first chaplain, of course, was an appointment by us as trustees, not by the head. And we certainly relied on certain things. The tutors, of course, the board would never have been consulted about the appointment of tutors. And a couple of the other people were more senior, and at the time would probably be bounced past the board. I don't know about Ian Wilson before my time and Rex McIntosh appointed before my time, but with the others, the more senior ones, the head would have said, look, we're down to these two, we're down to these three, what do you think?
So the interest of time, and also I recognise that you accept that a lot of the responsibility really rested with the heads to carry that monitoring oversight role.
Yes.
Can I just turn to another question, just following from my colleague Commissioner Gibson, about the composition of the trustees, because I understand that within the student body over time there would have been a fairly sizable number of Māori and Pacifica and other ethnic identities groups in the student body, and so it's not surprising, I suppose, but it does seem that the composition in terms of the trustees themselves has seemed to be largely white men. And I wonder what your view is now on reflection about whether that it would have been better to have greater diversity in the makeup of your board in terms of genders and perspectives.
A few parts to the answer, if I may. First of all, that's been remedied by the new chairman you'll meet shortly, in that there has been both gender and ethnic diversity in appointments under his chairmanship. Coming back to my time, yes, I would agree that some wider diversity might have or would have been better, but I would hastily follow that with a comment that I can't see for 1 minute how that would have avoided the abuse you've been hearing about.
I think it's the point that my colleague was pressing is you use the word someone of my age and worldview, I think, and if there are other perspectives that, multiplicity of perspectives, including younger views, let's say, that would help to identify systems, gaps and errors. That's the proposition we're putting to you.
Yes, I understand the point. That may be so, but I'm not sure of it, no.
You're not convinced of that?
No,
Okay,
no.
all right. Okay, thank you for your time. Thank you.
Mr. Firth falls to me at the end. I have a few questions. This has not been touched on yet, but it is coming up later in the morning, and that relates to the relationship between the school, Dilworth School, and the church, the Anglican Church. And I've noted in your brief, of course, you've said that the Dilworth Trust Board totally independent of the Act. I understand that. But we have heard evidence of correspondence, haven't we, between the school and the bishop? And I just wondered if you could explain, we understand the institutional arrangements, what's on paper, the will, etc. But in terms of the what went on sort of below that, what was the level in your day of the conversations, the interaction between the bishops and other members of the churches in Dilworth?
Well, in my time as chair, it was definitely confined to religious type things. That is the curricula that the chaplains adopted, how they were generally performing, and it was certainly not wider than that.
Okay.
In fact, I think Dr. Wilson makes the point in his detailed submission that it's probably not correct to define Dilworth as a faith-based school. It's a school absolutely independent of the church.
No, I truly
Yes,
understand
yeah.
that, and that's why I'm asking not so much on that, we accept that, but in terms of the way the formalities go. But I'm just wondering about the level of interaction that the board had, say, with the bishop, with any other. Was there any? We just need to know.
No. The board never met with the bishop except once a year when he presented his report. Trustees would see the bishop when the bishop attended chapel, and occasionally the bishop would have been invited to all the major functions at the school and perhaps attended half of them. So the trustees would meet with the bishop of the time when he had the inclination, willingness and time to come to a major function, and formally around the board table once a year when he presented his report.
And he would attend the board meeting and discuss the report with the members.
Yes.
Right. Okay. Thank you. Well, I won't take that any further. Just and we're hammering this point a bit, and I think it's important that we do. It's about this question of how it was back in the 70s and 80s, which you've referred to, and the different attitudes and the like. But I need just to refer to your brief of evidence. No, sorry, it's not your brief of evidence. It's in the responses. Is it a brief of evidence? No, it is. It's really answering the questions in the notice to produce.
Oh, yes.
Yeah. And you talk about your work outside the school, which my colleague Sandra has just referred to. And that was about your work with Centrepoint, where you were acting for a group of people who were objecting to Centrepoint. And in the course of that, you say that coming to light, you received and learned about a lot of sexual abuse that was going on at Centrepoint.
Yes.
And that was presented to whichever body. I think it was an environment.
Of various courts and
Various
planning
courts,
bodies,
right.
numerous courts.
But it
and
was
planning.
put there, and you express, I think, some disappointment that the evidence about that sexual abuse was not believed in those bodies.
That's right.
And that was work that you were doing back in the 70s and
Indeed.
80s, wasn't
Indeed.
it? And I just wondered whether you can remember what the effect of that disbelief was on you who were presenting it, and on the people who had given that evidence to you.
Well, I was certainly disappointed it wasn't believed. They were young women in all the cases at Centrepoint, and I did not speak directly with them. Their evidence was briefed and I led it. In fact, I don't even think they appeared. I think it was in a setting where they didn't have to appear.
Yeah.
And I had no idea of how it was affecting them, but by golly, as a result of this experience, I'm sure they were 100 times more devastated than we even imagined.
Yeah, I just wondered whether that experience, which you were having contemporaneously, I think,
Yes,
with whether there was any link between what was going on in that world and what was going on in your Dilworth world.
No, none at all.
Okay. Just moving on. And coming back to, I know you don't like the word systems, but it's the reason we're using it, it's in our terms of reference, and we're having to look at systemic factors.
Yes.
So however you phrase them, whether it's expectations or the like. You say in one of your, in response to we're asking whether there was a cultural practice of ignoring abuse, and you say it would seem that some of the abuse was well known among the students at the time, and they may have assumed it was more widely known. So this is again a hindsight thing that you now realise it may have been.
Yes.
Just in terms of systems, you've explained to us why you think that you should, the futility of having a rule, you shall not sexually abuse students. I'm just going to put to you whether you think it would be futile to have a protocol, a rule, a value, a statement to the boys. You have an expectation that you can bring complaints, that, you know, if anything's going wrong, you can come to us.
Oh, absolutely. That was brought in. I can't remember when, but a point was reached where the boys were warned and told that they must, speak to someone, and indeed, eventually, perhaps later than it should have been, but eventually it got to the point where I understand that every student, probably not the very senior students, but every student at the junior level had 2 other people to turn to. In fact, 3. They had a mate of the same year. They had someone older in the form of a staff member or an older student, and they had another staff person. So the point was reached where every boy knew that there were up to 3 people to turn to, and this was not for just for sexual abuse, but for bullying or anything inappropriate.
Can you remember when that came in?
No, I can't. I'm trying to. I think that might not have been until Mr. McLean became the principal in '97, which was late.
Okay, so it was late, although not as late as 2019. Do you know if there was any increase in complaints as a result of that? I'm trying to work out whether it sounds like a good move. Was it an effective one? Was it one that made the boys feel more open to disclosure?
I don't know, but I know Mr. McLean thought it was a good scheme, and he made sure it was kept alive.
Okay.
Can I just touch on the protocol point again? Because
yes, sure.
It would be a terrible distortion of my evidence if it was a headline tomorrow that I said there should not be a rule against sexual abuse. That would just be abusing what I've said. One would not expect to see in a protocol a rule that you should not burn down the buildings. One would not expect to see a rule you should not poison anyone. One could go on forever. There could be 30 examples like that. So, and yes, of course it's sensible to pick out abuse, absolutely, but surely the real point of it is to have it there as an example of grounds for immediate dismissal, because it would have to be...
That's a formal way of doing
Yes,
it. I accept that.
yes.
Just your reference to the headmaster brings me on to my last point. I think you've made it very clear, at least in your time, that the board is very reliant on the headmaster to be its arms and legs, if you like, to be the person who implements the values, the tenor, the operations of the school. And the board, of course, must place great trust in the person who holds that role. You agree with that?
Yes.
Yeah.
Yes.
And I expect there were, with each headmaster, the board would form a relationship of collegiality with the headmaster,
Yes.
Trust and confidence and the like.
Yes.
Did the board have any, I'm going to say the word protocol again, it's almost triggering us all today, but did the board have a process for monitoring the work of the headmaster? So some sort of, I don't know, performance evaluation of a regular sort and all the like?
Oh, yes. There were a number, and I can't immediately think of them all, but I can think of one, and that is that there was a performance review meeting every year, and while I was either deputy or chair, I always participated in those annual performance review meetings, and we would gather together discrete inquiry and discrete information from senior staff and others about the school. I don't think it occurred to us to gather information from the students.
So I was going to ask you that.
Perhaps we should have, but we didn't. And these were quite rigorous meetings. I learned in my former law firm on this topic that what employers must not do is schedule the annual review and then be too busy or cut it short or, whatever. It has to be of full duration and uninterrupted, and we certainly observed that with these annual reviews of the heads. Well, I wasn't involved in the one with Peter Parr, but with Murray Wilson and Mr. McLean. And these were quite rigorous, and indeed they led to, formal note being issued about their strengths and weaknesses, aspirations for the next year, the usual things you would put in that sort of document. So the heads were very aware that they were under watch from the board. They were very aware of the no surprises requirement. Yes.
Okay, and we're over time, but just very quickly, and in those reviews, do you recall whether the question of the incidents, events that had come up in the course of, in relation to the abuse of boys, was that raised in those meetings?
I don't recall abuse being expressly raised.
Okay.
And I was at most of them.
Thank you. We've come to the end of the evidence, just slightly over time. But Mr. Firth, can I thank you very much on behalf of the Commissioners for your cooperation with the Commission, your willingness to come forward, your very considered and in-depth brief of evidence, and the statements, the preparation for that today. It's very important that as Commissioners we get a full rounded view of what's been going on, and you've helped us immeasurably in that. So thank you very much indeed.
Thank you.
Much appreciated.
Thank you.